Judge is going to be coming down momentarily. We'll let the record be.
related to Mr.
Elaine, that's correct.
Elaine, is that right? Okay. Let me just say, I did have a couple of questions for you folks before I turn it over to you, Mr. Brado.
Sure.
Does the Commonwealth intend to call Mr. Elaine at the trial?
Yes.
Okay. All right, so I guess a couple of observations, Mr. Grado, then I'll turn it over to you. One is that your affidavit in support doesn't mention Mr. Elaine at all. So I'll just point that out to you. Also, the proposed order doesn't mention him either, or who the subject of the records would be that would be ordered to be produced. And also, essentially, if I understand this correctly, and I did review, there was video footage that you folks dropped off last night, or at the end of the day. I couldn't get the other phone drive to open, but I did review the video footage. But if I understand, generally speaking, that there's these multiple instances, if I remember correctly, in April or in May of 2025, where Mr. Elaine is observed on this video. I assume that at their residence at the time, smoking marijuana or something.
Yes, Your Honor, that's what we would allege.
And so, and your argument is somehow this would be relevant to Mr. Elaine's ability to perceive the events and hear the events accurately and then relay them. So, but how was, let me ask you this, marijuana is legal, right, in Massachusetts, as is beer. So if the video displayed him, Mr. Elaine drinking a glass of whiskey or beer, the number of times that you saw him.
What's the difference?
Right. What is the difference?
Happy to answer, Judge. So in this case, the state of the evidence is that we gave you 4 or 5 clips as a representative sample of over 200 clips that we have that are similar over a long period of time. And
in other words, 200 instances
maybe
of,
270, I'm being a little conservative, but over 200, let's say.
all right, over 200 instances of,
What you see in the representative sample.
okay, and what was the time period?
So the time period would go back probably a few months, Judge.
A few months before the June 30th incident?
Correct.
Okay,
Correct.
all right. And this is something that that has been produced to the Commonwealth?
Yes, we sent them, and actually we got it from the surveillance that the Commonwealth had that they returned to us recently.
Okay.
So they definitely have everything. And so, Judge, it's fair to say that there's a pervasive marijuana use by this guy.
Okay.
And I understand, your point that marijuana is legal in Massachusetts. It's illegal under federal law, number 1. Pages 37 and 38 of the town of North Andover policy and procedures have a very comprehensive anti-drug policy for all town employees, which my brother and I were just discussing. It's a public document, and it prohibits any drug use on town property, prohibits any showing up to work under the influence of any drugs, no smoking. There's also a statute.
But what's the evidence? I get all this, I certainly understand. And I certainly understand that there's plenty of legal substances, including alcohol and marijuana, that would absolutely affect a person's ability to perceive and recall and et cetera. He testified credibly. But what is the evidence that on June 30th, that whatever time in the morning it was when this incident happened, that Mr. Elaine was under the influence of something at that time?
So, Judge, it was the afternoon, and the idea is that, the pervasiveness of the usage raises a legitimate question. And this is a discovery question. We're not talking about an admissibility question at this point. We're just talking about a discovery question and I would venture to say that the standard there is that is something.
I'm sorry, Steve.
Yes,
sir. But the case law is clear is that this can't be, I just was reading Commonwealth versus Jones, I think, which is clear that this can't be, Rule 17 can't be used as a discovery tool. It's a tool to make the trial more efficient. In other words, you have to show that the evidence would be admissible.
Yes.
Right? So.
Well, I mean, it sort of is a discovery tool in the sense that we get the documents early. And in order to get the documents early, we have to make a showing. And I think the showing is made, Judge, in terms of relevancy of his ability to proceed and recollect. That's something that's always relevant. And so we have documented video of him smoking marijuana all over his home all the time for months, over 200 times. And so the pervasiveness of it, I would suggest, points to that there's a problem, number one. Certainly the problem with this guy. But number two, Your Honor, that there's likely to be overlap with his work schedule as a firefighter, where it would certainly come into contravention of town policy, which is page 37, 38 of the town policy, which prohibit showing up to work under the influence of marijuana. And that would trigger the further town policy, which is that if there's an incident, there should be random testing of town employees. And so we think there's a good faith basis to say, give us this early, Your Honor, that if he's been tested at work and he tests positive at work, he's been given breaks at work, he's been put in rehab from work.
But how would that be admissible? So that would,
So
let's assume he, even 2 days before, on the 28th, his screening came back at his employer for positive for THC.
sure.
Okay, so then what?
So I have a good faith basis to ask him on the stand, were you smoking on when this happened? Do you remember these events accurately? Do you even know what you were doing when you were in that basement? Do you know, you're taking your baby under the influence of marijuana?
You don't think you have that good faith basis to ask that question now?
Well, there's always,
200.
I don't need to tell you, Your Honor, trial lawyers are worried about when the guy says no. And that's why it's a discovery matter in terms of, ultimately it would be a discovery matter to get the stuff, but, the lawyer is always at the mercy of someone saying no. And then if you have the backup, we can, as we say, we can prove it up. So it is relevant in that respect of us needing to know how pervasive his marijuana problem is. And we have pretty good evidence, times 200 and whatever, that it's a pretty pervasive problem. And so I think it's probably meets the relevant standard, the lack of fishing expedition. We can't get this material anywhere else. This is something that is important to make sure the cross-examination is appropriate and can be proven up. So I think my good faith basis kind of comes from being able to prove it up. And that's one way I can do that. I always have in mind, Judge.
But then I'm not sure that the record, again, but the balls and strikes that I'm being asked to call in this narrow instance under Rule 17 is keeping in mind that you're asking for me to order production of records, of employment records. Again, I'm not seeing how that has any materiality or relevance to what his state of mind was, Mr. Elaine's state of mind was at the time of this incident.
Well, I think you gave me my answer. When, maybe there is something in there just right up against this incident. Maybe he was under monitoring. Maybe he was reprimanded for coming in smelling like marijuana. Maybe he, had some marijuana at the fire department. We have to look at the records. I don't have a magic wand when I say, exactly what they might have, but I can point to relevancy and materiality and lack of fishing expedition by saying we have 200 something instances of him doing it over a few months. That creates the likelihood that there's some overlap with work. And then, so then we have town policies, and then there's also another law, Judge, that's chapter 40, section 101A. It prohibits hiring of firefighters who smoke for pension purposes. The Commonwealth doesn't want to get into smoke or fire. So,
Mr. Gray, all of these statutes that, again, I don't take issue at all with, I asked that rhetorical question to start with, but I don't take issue at all with the notion that marijuana can, and especially something that's smoked off and can affect someone's ability to proceed and then relate what they saw and heard on the scene. It's the idea of getting records that you are fishing for, arguably, no? Because, hold on.
okay.
Again, I'm constrained because the case law says that this is not to be used as a discovery tool. Now, let me say this, I've been there before, and I know that you're between a rock and a hard place because you have some information like you do about the possibility that they'll be in the records, but the SJC has made it clear that you need more, I believe.
So you're the judge and I respect your ruling, but I should just say.
Well, I haven't ruled yet, so.
I appreciate it. My thought is that whole business about it not being a fishing expedition, I think that what they mean there is that you can't be held, the defense can't be held to the standard of knowing what the other people have without getting to it. It would be easy if we could say, I know they have 16 reports from 16 days that he showed up smelling like marijuana and stumbling around. But, that's never the case because this is adversarial litigation. And so we don't know, and we never do know. So the courts can't put the defense in this catch-22. We have to ask for the records, and it can't be a situation where, you have a time machine, you have a magic wand, whatever you want to call it. We don't know. Defense counsels never know. And that, it can't mean that Rule 17 means nothing. So you have to interpret this fishing expedition thing as meaning just completely throwing darts. And so what I'd answer to say why we don't have a fishing expedition here is because, excuse me, we have this incredible number of video documentation. And we know that he's a full-time firefighter in the town. And so the likelihood of an overlap is pretty substantial. So that's really all we have. And that's all a defense counsel can ever have is kind of skirting around the edges.
And in fact, arguably, you have more than we often see, right?
I think so, Judge. So, this is just, this is asking for records that will potentially be able to give me the ability to prove up a denial, I think, if you will. And, who knows what he's gonna say? I don't know, because he's an adversary. So, I'm just trying to get the record as populated as possible. And if I have information, I'll know the parameters of what he's saying is truthful and what is not truthful. And I think it would make for a better cross-examination and a more economic cross-examination if I'm not dancing all around without the benefit of these records. So that'd be my argument, Judge. Thank you.
Kamala?
Well, I think I just echo much of what you said, and so I hate to do that, and echo what he said. He said, maybe, we don't know. That's the definition of a fishing expedition. That's the definition of a discovery tool, and that's what he's looking for, and he well admitted it. He has a basis to ask that question. He could ask the witness on the stand, were you under the influence, or had you smoked, or anything like that? He has a good faith basis to do that. I wouldn't object to that question. I think it's a fair question based on the landscape that we have here. And the answer is what the answer is. And that's often the case. So I would suggest to you, he has not met his burden, and the court should deny the motion.
Mr. Gray, anything else?
No, Your Honor, thank you.
No, on that.
No, that's all I have for that, yes.
So I'm going to issue a more formal ruling later, but the motion is denied because the defendant has not met her threshold requirement under the land pond protocol. And as I said, I'll be more specific in my written ruling later. All right, now that's moves us to just. All right, so, I thought we would then go to the defendant's motion in limine, which has various requests. Let me just get it from the paper 67. Now, I meant to point this out even before we started on the Rule 17 motions, but I think it's worth saying. So, Mr. Gubitosi, at the last hearing, you said this is something to the effect, and probably more eloquently than I can remember, but something to the effect of that this is a very simple case, straightforward about what happened in the bedroom. And I'm glad to see that the defense seems to agree, because in this particular motion, Mr. Gradle, you wrote, the narrow issue here is whether Ms. Fitzsimmons committed an assault with a dangerous weapon against Patrick Noonan on June 30, 2025 in the bedroom, et cetera, et cetera. So I point out that you folks agree. So that's my thinking here, in trying to keep things simple when I'm addressing all of your motions and your trial motions and your requests. I agree that we at least have an agreement on a starting place. But let me hear you, let me ask the Commonwealth on the defendant's motion. So as for sequestration, let me say this, I typically don't issue sequestration orders like formally. In other words, I would ask the Commonwealth. I would just rely on if there's an order in place for you folks, both sides, to tell your witnesses that how it works. So does the Commonwealth object to a reciprocal sequestration? In other words, yes. Sorry. Thank you. So I'm going to allow the request that the trial witnesses be sequestered as that term is used in your motion, and it will apply to both sides. So I would, you'll be responsible in conveying to your witnesses that particular order, that they're not to discuss their testimony with other witnesses. All right, and on number 2, the opinion terms. So I almost always use people's names, their surname. It's very possible, if not probable, that I would use a term like alleged victim, who I believe would theoretically be, not theoretically, would be Officer Noonan. Thoughts?
The Commonwealth has no objection to number 2, so long as it also is binding on defense counsel.
Meaning what?
He also refers to anyone as victim, suspect, target.
Right. So are both sides okay with alleged victim?
Yes.
Of course, yes.
Okay. All right, so I'll allow that. And I'll write this up later so that we're not. And number 3 is basically a motion to preclude prior bad acts or other acts. And let me say this, it probably makes sense to hold off on this because I do this as an opposition to a couple of the Commonwealth's motions, I think. So just remind me to straight and circle back if I haven't addressed everything.
Certainly.
In there. Number 4 is voir dire. Let me hold off on that for a moment because the Commonwealth also has voir dire, proposed voir dire. But let's go to number 5, which is the last. So number 5 is that the court exclude. There's a lot there. Commonwealth.
I mean, I think most of it is not really applicable to the facts of this case. So insofar as, the defendant is known to other members of the North Andover Police Department because she was a North Andover police officer. I think that's kind of unavoidable. They're
But not a
literally
repeat offender, that's what I'm.
certain not repeat offender. And I think the defendant did never fled anywhere. She was never a target of any, broader investigation. So I think as this is somewhat boilerplate, it doesn't really apply to the case, so there's no objection.
All right, so that will be marked as allowed without objection. And we really should at some point talk about, and this may arise during the hearing on one of your Commonwealth's motions, but talk about the scope of what the evidence will be as it relates to this 209A work, right? And I think we need to flesh that out, or maybe it doesn't need to be fleshed out. But we'll get to that in a moment. So that leaves paragraph 4 in the defendant's motion, which is request for a voir dire. And while I'm addressing the defendant's request for voir dire questions of jurors, let me get the commonwealth's out. Paper 63 is the commonwealth's request for jury questions. So let's just go back for a moment. As I said, I intend to handle this impanelment like I do all impanelments, and that is to use a case-specific juror questionnaire in addition to the single-page questionnaire that the jury commissioner issues with the summons. So my philosophy is, and also you folks will have, we will conduct individual voir dire of every juror, whether they answer yes question any of the questions or not. You folks will have permission to ask reasonable questions as part of attorney-conducted voir dire. My philosophy is to put as much of the questions you folks think are relevant in the questionnaire, so that it just will speed up the process. Obviously, you'll have your own things that you'll want to maybe ask personally, which means that the questions have to be formulated in a yes or no, in a manner that calls for a yes or no answer. So when I look at the defendant's request, I mean, I definitely can include something like A and B, C, mental health issues in general, and yeah, D will be in there, E will be in there. Yeah, F I don't ask, I'm not saying that you can't, but same thing with G. I mean, there's obviously versions of F and G when they're asked whether they can obey the idea of the presumption of innocence and reasonable doubt, et cetera. Same thing with H and I and J. So all of those things are kind of covered. But you'll be free to ask follow-up questions or questions that pertain to that. Now, so on the K, I'll formulate something. Does it make sense to have some kind of question related to groups such as, I don't know if this is still pertinent, this is from years ago, fathers' rights groups, groups that may advocate for Second Amendment issues. I don't know, things of that nature. They can be grouped together, but I think K is just too broad. So I'd be amenable to, again, asking for, if they've ever, if a juror, potential jurors ever donated to or volunteered for a domestic violence related organization, or if that's what folks think, or some kind of a parenting, shared parenting organization related to that.
Yes, I think we should do something like that. I trust your judgment on that.
Same.
Okay, so on the Commonwealth's and paper 63, I think I cover almost all of this, at least on the first page, second page. So it does make sense to ask about, as the defense requested, suicide, mental health, in general, postpartum, even, I can formulate some questions related to that. Training and experience with mental health issues. I don't know, is mental health gonna be a issue? Well, it's gonna come up at some point, right? Even on a limited basis.
I think it's gonna be very tangential, John. You know, I think it's really more about, and actually, my brother and I just hatched out a agreement that the way that this was served, as they all are, is without an affidavit. It was just served, the order was served. And I think we have a stipulation that we can just admit what was served, the restraining order. And the terms of the restraining order are what we both, literally, we were just discussing this, what we both are interested in utilizing. So I think that will probably cover the issues that we both are concerned about without opening too many doors on either side.
So I guess the question is, do you think I should stay away from 8, 9, and 10 and 11? Or do you, that being on the Commonwealth's request, or do you think that those things are worth asking about?
So I have an objection to 8, 9, and 10, because I think it's kind of suggesting things that aren't gonna come up. You know, mental health disorders, I don't think that's really gonna be something that's gonna be discussed at this trial or largely discussed.
But you folks are asking about suicide, so wouldn't that beg the question? I mean, obviously, there's many reasons that people commit suicide.
Not necessarily, you know, I don't want to invite some sort of wide-ranging exploration of, you know, Ms. Fitzsimmons's medical history. And not to suggest there really is anything that's, you know, awful. I mean, we have postpartum depression. Whether that becomes an issue in this case, I don't expect so. I think she was served with an order that did 4 incredible things to her life and would do 4 incredible things to anybody's psyche. She lost her 4-month-old child in the completely out of the blue. She's home with her baby in sweatpants having fun. She loses her 4-month-old child. She's betrayed by her fiance. Her marriage is over, ain't gonna happen necessarily. And you can picture her sort of almost having this realization. Her job's over, her guns are gone. Again, she just got them back. There was a 100-page report clearing her of anything and putting her back at work. She was going on a schedule in 3 or 4 days. And the other thing is that she was completely humiliated in front of her own work friends and colleagues. So I don't think we need to really go to dig up any sort of diagnoses, especially something as common and, you know, expected in a woman as postpartum depression as a reason for wanting to just end it all in a brief, half-hearted minute.
Okay. So the bottom line is you object, the defendant objects to 8, 9, 10. How about 11? Just the training related to mental health.
That one, we're okay with that.
All right, so 8 to 10. So let's just take them a bit at a time. Commonwealth, from your perspective, as to 8, 9, and 10.
Obviously, we cannot predict how the trial is going to proceed. However, based on counsel's representations here and prior public representations, it seems like the defense is going to be that based on the confluence of those 4 factors, the defendant claims that she was attempting a suicide attempt. I don't know how you divorce suicide from mental health issues. I think that the two are one and the same. When someone hears suicide, particularly in a jury pool, they're going to think mental health. I think it's going to come up that why did Justin have it's not guaranteed to come up, but the fact of the 209A order suggests that there was a reason why a neutral magistrate determined that Mr. Alien should have custody of the child. So I think mental health is an integral part of the case. The Commonwealth is not shying away from that. I think that we need to ask the jury about it because depending on how this trial goes, it could be very narrow, it could be a one-day-long trial. It could be much longer, depending on how things go. So I think we need to really probe the jury and find out what any biases that they may or may not have with respect to mental health in general.
Okay, mental health is an easier concept broadly because it's been raised somewhat by the suicide request by the defendant. But as for specifics related to postpartum, so does the Commonwealth believe just in your case in chief that would somehow come out?
No, but I mean, there are signs outside talking about postpartum depression is not a crime. So it would be.
And in the end, how come I remember, I'm surprised that this, Mr. Grado, the postpartum depression is controversial from the defendant's end, because I thought I read in some submission somewhere that was a fact from your perspective, right?
So as we're evolving kind of towards trial, Your Honor, it occurs to me that the cases really doesn't matter much about why the person got an order, what was going on with these people. The police are serving an order. That's their legal duty. It doesn't matter what the order says or how it was gotten, or whether it's based on truthful information or fraudulent information. They have a duty to serve an order.
Okay, but let me ask you, tell me the facts about the service, the actual service of the order. And that is that, does the Commonwealth believe that the evidence will be that the defendant read the order and understood it before, in other words, processed it somehow and before the shoot?
Yes,
Okay.
you process the order, not the affidavit.
Not because the affidavit wasn't there. All right, so Mr. Grado, presumably, and you said this, is that your client's state of mind is significant, right?
Right.
Because she has to have intent, right? And there was some mention in some filings about perhaps she was pointing the gun at herself. You asked about the suicide attempt. So I'm failing to see how just asking a question about postpartum depression somehow prejudices the defendant.
My
I'm
thought
not
is,
suggesting that it would be admissible or not,
Right.
it's just a question.
right. I mean, I'm concerned about the degree of disclosure, and I feel like, the second it gets mentioned, that the government's gonna allege that we've opened the door to something, and that all of her prior incidents are relevant, and now they have to come in about postpartum depression. So, where I have an order that did those things that I just recited a few minutes ago, I don't really think that, we don't need to gild the lily here on, and on top of that, she has a bit of postpartum depression. How far do I have to go? Those things that I said are eye-popping. To have that happen to anybody out of the blue on a nice summer day when you're home with your baby.
Especially if they're suffering from mental health
I agree.
conditions.
I agree, but I don't want to open the door. If
You're not, so let's be clear.
Okay.
We still need to drill down on, at least I think we do, on what is admissible broadly in this area. All I'm addressing right now is the simple yes or no question related to postpartum depression. And that is whether they have any experience. I could use something similar to Ms. Moriarty, were you in the Brito case, where there was a significant mental health issue or issues. And it would just be yes or no. It's not, I would never say, there'll be evidence that the defendant, no, it's just your experience with that.
You're giving me a comfort level, Judge, and I'm okay.
Oh, okay, but the other thing too is just understand this, is that I'm gonna take the information that we gleaned, that we discuss now, put it in a draft of a questionnaire that we'll go over before it's disseminated, and you'll have an opportunity to see exactly what it is I'm asking. I was hoping that would be today, before they're disseminated. Before I forget, while we're talking about, so give me an opportunity to
Okay,
put that in there.
I'm okay with it.
And
Just give me a comfort level, Judge. I'm okay.
You don't need to be comfortable. All you have to be comfortable is that it's gonna be in the draft, and you'll have an opportunity to see exactly what
All right,
I'm
thank
going to ask. And that's for all of these questions. But can I hate to float around, but one of the issues I have is related to the draft of the juror questionnaire is, I think that there's obviously media attention to this case, there's public attention. The public and the media have a right to and the defendant to a public and fair trial. I'm concerned about having a draft of the juror questionnaire getting out there by mistake or et cetera. So I'd be inclined to simply impound it, disseminate it for your eyes only, obviously to provide, show to your client, and just impound it until we get to, and then we can talk about what we do with the final one as well. But any objections to that from either side?
No, I think it's a great idea.
Okay.
Okay, all right, so that's the way Mr. Willing is, remember that's the way we'll handle that. All right, so I think that, does that cover everything? I think firearms related questions in Second Amendment type of stuff that I typically ask in a firearm possession case would be pertinent.
Isn't that fair to say?
Yes,
So then you touch the gun, right?
I do.
And then you move it to the white shelf, bookshelf.
Yes,
And then Core arrives. And
Yes.
then you tell Core to grab the gun and secure it,
I
right?
do.
And then Core has it. Does he take it into the hallway?
Maybe. I remember just focusing my attention on Kelsey.
Sure, understandable. So you're focusing on Kelsey and you're giving her first aid.
Yes. Well, Lieutenant Daly was starting to work on her.
Well, is it fair to say that at first you still had your gun on her, but then you helped with the first aid?
Yes.
Okay.
Afterwards.
So that was your primary focus, was once you felt that she was not a threat to you on your testimony, you started to assist with the first aid, right?
Yes.
And you and Daly are rendering first aid, and then Core comes, right?
Yes. Yes.
And you say, get that out of here, secure the gun.
Yep. Make it safe.
Okay, so it's fair to say that Core does that, but your attention is not on what he's doing, it's on rendering first aid, right?
That's correct.
So you don't have any knowledge or observation of what Core did with the firearm, right?
No.
At some point, are you aware that Core takes the green safe and the firearm out into the hallway?
I didn't see him do any of that.
I show you Exhibit 51. Do you recognize that?
Yes, I do.
So Exhibit 51 is the left side of the door frame where you say that Kelsey lunged, right?
That's correct.
Is that how it looked when she lunged over there?
I didn't see that when I was in the hallway.
Do you know anything about that shoebox with the orange lining?
I have no idea.
Do you remember seeing that chest with the brown leather trim on it?
I thought it was an end table when I walked out of the room.
Do you think that the gun came from any of those areas there?
With how quick she grabbed it, I think it came from that box, but I don't know.
Show you Exhibit 36. That's a picture of the stairway, right?
Yes.
It's pretty narrow.
Yes.
And you went up to the top and you were at that landing, right?
That's correct.
You never entered Kelsey's room?
No.
So you said that you were shocked that Kelsey was quickly grabbing a gun and putting it in your face?
Yeah, absolutely.
And you that she'd gotten the drop on you, right?
Yes.
And at that point, you feared for your life, you say, right?
Absolutely.
And you panicked and you shot her.
No.
Well, you missed her from just a few feet away.
It's hard to shoot a moving target or anything moving.
Are you aware of the Post Commission?
Yes.
And you know that the Post Commission has issued regulations that are in the Code of Massachusetts Regulations.
Yes.
And you know that it's prohibited to use deadly force on a person who is exhibiting a danger only to themselves.
Absolutely.
And you knew that on June 30th, 2025, didn't you?
I've known that since I graduated the police academy in 2006 or even before.
Right. And you went in there thinking that Kelsey was dangerous and had guns and you might get into it, right?
That's inaccurate.
And that's why you had your gloves on, isn't it?
No,
You were ready to get wet.
no.
I'm sorry, ready to get what?
Get wet, Your Honor. And that's when you had to adjust the narrative, isn't that true?
No,
So you're going to maintain that you got into a gunfight with somebody who was your colleague, right?
yes,
Who had just given you her baby to feed 5 minutes earlier
yes,
of her own volition.
yes,
She developed some sort of a homicidal animus towards you for what Justin Elaine just did to her, right?
I don't think it was, unbeknownst to me, I didn't know Justin was in the house. I think I was standing in her way for her to get downstairs and kill Justin.
I assume this is in hindsight.
Hindsight, yep.
Please, one moment, please, Your Honor.
Take your time.
Did you have a taser?
I did.
Did you think maybe to use the taser when she pulled the trigger and the gun didn't go off?
No. You meet deadly force with deadly force.
She's 3 feet away from you?
Yes,
Could have just grabbed her, couldn't you?
no.
And if there was deadly force, you wouldn't have stopped at 2 shots, would you? You would have emptied that magazine right into her.
I stopped when she stopped. And that's what I'm trying to do. Stop the threat, not empty a mag.
What were some of the things that she asked you to bring downstairs?
I think there was a basket of books, and I believe some clothes. I think she put him in a car seat.
What did you say to her when she asked you to bring him downstairs?
I said, we'll deal with that later, and I put him down.
What was her reaction?
She just kept packing stuff.
So you said that you were you'd started your career in the North Andover Police Department, correct?
That's correct.
And you left for the Lawrence Police Department in what year?
2011.
And then you were on the SWAT team from 2019 to 2024, correct?
That's correct.
And that you left North Andover to get a faster pace, right? What do you mean by a faster pace?
Busier. Are you talking about when I left North Andover to go to Lawrence, or?
Yes.
A busier atmosphere,
More action.
more calls for service,
More what, I'm sorry?
calls for service.
Calls for service.
I wanted more experience.
And you were there for how long?
In Lawrence?
Yeah.
From 2011 to 2024.
2024, you go back to North Andover, correct?
Yes,
And you said that you wanted to bring your training and experience back to where it all started, right?
yes,
Meaning you wanted to offer officers at North Andover the benefit of your training and experience, correct?
correct.
You said that you only have 10 years left, getting older, the slower pace is what's needed, right?
Yes,
So is it fair to say that the stress of a busy urban department was getting to you?
no,
Well, you did tell Kelsey that you had PTSD, didn't you?
absolutely not.
So slower pace, and you just wanted to grace the department with your training and experience, correct?
Yes,
Is that right?
yes,
Judge, I told counsel that I would ask for a sidebar before the next topic. Sure. reprimand letter was not going to be issued, and that at some point it was sort of a after the fact thing that it was in fact issued for appearance's sake, and that originally there was going to be no sanction whatsoever and no exploration into the, and I won't say it, but the reasons why he missed his shift.
Okay, so let's say there that the proposed question is, Officer Noonan, isn't it true that on such and such a date, you know, you overslept because of some medication, you missed a shift, you were deemed AWOL, and you only received a public a written reprimand when policy called for you to be subject to the death penalty. And so that's the question.
Right.
And he says, yes, no, okay, then what? Let's say he says, no, that's not true.
Well, we have the letter, Your Honor, at minimum, we have that.
All right, so, all right, and then the last item is that he was put on administrative leave and allowed to work details in violation of policy.
Right.
And you're saying that that's ongoing?
That's my information, Judge, is that he was working details and
What's the source of your information?
another whistleblower. And, you know, they come to me in good faith and, you know,
And have you vetted these whistleblowers?
Yes.
Listen, frankly, if this was a jury trial, and I realize I'm talking out of two sides of my mouth again, because I said yesterday we're going to treat this just like a jury trial. If this was a jury trial, this would be an easy decision. The decision would be not even close on your proffer, denied. The objection would be sustained. I'm going to allow one question each as to each of these areas. Mr. Brado, you'll accept whatever the testimony is under oath to that answer to that question. I'll just remind you, because I'm reminding you, I'm really saying this for our audience, not you personally, but I'll just remind counsel that questions of witnesses are not evidence. The evidence is their answers. So that's what will be used or could possibly be used in your closing argument. I'm going to allow one question each as to these areas, and you'll have to live with the answer that is provided under oath. Okay?
Yes, sir.
Okay. And do you need to speak with Officer Noonan about this before he returns Commonwealth? Okay. All right. So he may resume the stand, Officer Noonan. Thank you, Officer Noonan. And Mr. Brado, you may continue your cross-examination.
Thank you. Sir, I want to ask you some questions about some of the treatment you've gotten by the North Andover Police Department since this incident. Sure. Okay. Now, after this incident, immediately after this incident, you were not drug tested by the town or the police department, correct?
No.
And you're aware that's a policy of the town?
That I don't know.
You don't know the town policy?
As far as the drug testing, no.
Now, you also are on critical incident leave right now, or word to that effect, right?
Yes,
And that means that you're not able to perform the duties of a police officer for the time being, so you get put on leave, right?
yes,
And yet at the same time, you're being permitted to work as a police officer on paid details, isn't that true?
yes, that was our union.
So it's just it's a yes or no question.
Yes,
And that is an accommodation that was made via a side, may I inquire, Your Honor, or?
We've already gone past one question.
Yeah, staying, next question.
That is something that is not ordinarily permitted, is it?
Uh,
No, you've gotten your answer, okay?
Okay.
Next question.
All right. Now, you also were absent without leave from a shift recently, correct?
back in January. Yep.
And with respect to that, there was a reprimand letter issued to you, correct?
That's correct.
And at first, that wasn't going to issue, was it?
All right, let me just hear the question. What I was really expecting was one long leading question each, but that's all right, you're breaking it up. Let me just hear the question. Officer Noonan, please don't answer it
Yes,
until
sir.
I hear it.
So-
Go ahead.
The question, Judge, is that reprimand letter that appeared in your file was originally not going to issue against you, was it?
All right, that's the question?
Yes,
Okay, and you're gonna live with the answer?
yes.
All right, yes or no? If
I have
you're
no, I have no idea. I was just called in one day to sign it.
Okay,
So I have no idea if it was or it was not.
all right, so, that
Okay,
is-
that's all I have, Your Honor.
Okay, all right.
Thank you.
In that area, you're not done with cross, right? I'm assuming that you're.
In that area,
Okay,
right,
all
in
thank you.
terms of rewards, Judge, yes, that's all
Thank
I have. Now, I want to circle back on a couple of things. You gave a recorded statement to the state police on July 3rd, correct?
Yes,
And we talked back and forth about your belief or your expressed intent to section her, and you said that wasn't the case, right?
can you ask that again?
Yeah, you
Kinda-
said
I'm
that,
kinda
that there was
confused.
discussion about sectioning her, but that wasn't your thought process, or you didn't know about her or whatever, right?
When we discussed it, behind the school, it was brought up that she may not take this well. She may have to get sectioned. She was sectioned prior. So
So here you're saying that it was a speculative possibility, is that fair to say?
it could have been a possibility depending on how she took the restraining order, respectfully.
Judge, if I may, I'd like to play a recording from the state police
Okay.
interview from July 3rd.
For impeachment purposes?
Yes.
All right, any objection? Okay, sure. We should probably, we need to mark it for ID at least, unless you're seeking to admit it, but let's take it a step.
I'm just I'd be playing a prior inconsistent statement, Judge, for.
Okay, so we're gonna have to mark it for ID. I don't know, do you have a mechanism to be able to do that? Is it on a thumb drive or something that can be marked? If you're not able to do so today, tomorrow morning, just please bring in the recording that's being played and we'll mark it.
Certainly, Your Honor.
Okay, all right.
Say had just taken out a restraining order and we were there to serve it, confiscate her firearms, and then we were gonna section her.
So that's what you said on July 3rd, that we were going to section her, right?
Yes,
So at the time, you had it in your head that she was someone who needed to be sectioned, right?
if that's what I said in the statement, then yes.
In other words, somebody who was mentally ill and a danger to themselves or others, right?
Yes.
And that never panned out, right?
No, it didn't,
Because she was shot in the chest and went to the hospital for 53 days, right?
because she tried to kill me.
Now, I asked you earlier about whether or not you talked to Ms. Fitzsimmons about PTSD type symptoms. You recall that?
No, I don't.
You recall me asking
Oh, you
here
asked me,
today?
yes.
And isn't it true that you went on a call with her in August of 2024? That was a extremely difficult call involving a murder-suicide where the murder was of a baby.
Yes,
right?
it was horrific.
And you and Kelsey went to that call, right?
With other officers, yes.
And you had shared some texting after that, right?
Yes, I was being a senior officer trying to help out a rookie go through a traumatic event.
And your phone number, I don't want to give out the phone number, but it's fair to say that you had Kelsey had your phone number.
Yes, I think we were all in a group text.
And it's a 978. Just leave it there.
That's correct.
Okay. And so in that text, you said to Kelsey, relating to your past career, I spiraled down a rabbit hole, a very dark place. This happened years later in my career. We can speak in person about that. I have a guy I've been going to for years, like 10. And when I feel like I'm off, I call him, and all I have to say is, I need a tune-up, and he does me in. Right?
I don't recall that, but if that came from my number, then I had that conversation with her. I don't remember that at all.
Okay. May I approach her? Yeah. And I apologize, I have to do this on the cell phone. This just came up this morning. I didn't show it. Okay. May I approach her? Yeah. So I'm going to show you some of these two screenshots, first of all. First of all, that's a contact, and that's your phone number, and it says Noonan, right?
That's correct.
Okay, so this is the text I want to show you.
Which one? This one right here.
Yeah. And you can scroll up and down if you want, but this is the black part is you, and the blue part is Kelsey, right? You can get some context.
Wait, I'm in blue?
Kelsey's in
Oh,
blue.
Kelsey's
and
in
you'd be
blue.
in black, yeah.
So can I just make an observation? So you asked the witness about this particular text, about essentially that perhaps he had therapy and needed a tune-up, et cetera.
Yes.
He said his answer was he basically is not contesting the
Yes.
authenticity of that. So what are we doing?
Well, it's tricky, Judge, from where I sit, it's tricky that when a witness says, well, if that's what it says, so I feel like I need to establish that's what it says, that's all.
Okay.
And so,
Fair enough.
and I think I can leave it there. Officer, is that what it says, what I suggested?
It does.
And so we agree that you communicated that to Kelsey?
Yes.
And we can agree that that's pretty personal stuff to share with somebody that you say that you didn't know very well, isn't it?
Again, senior officer, she's going through a lot. I was just trying to be there for her. And that was one horrific call.
And we agree that that's something that can create very profound bonding between officers when you have a common tragedy that you have to deal with.
Yes, but you move on. You go back to work.
I want to go back to the bedroom where Kelsey's on the floor and you stop holding the gun on her. You assist Lieutenant Daly with first aid.
Yes.
Okay. And you were asked by the ADA, what did she say when she was on the floor? Recall that?
I
Just
don't
yes or-
remember
just
that.
Yes or no, just the context of being asked that.
Maybe.
And see if this refreshes your memory. You said that she said, it hurts. She said, it hurts. I, meaning you, said, keep breathing. You have a baby to live for.
Yes.
Right? And that was your testimony about what she said and what you said, right?
Yes.
And that was the truth?
Yes.
And that was the whole truth?
Yes.
Now, when you were interviewed by Attorney Bennett of the CIC investigation,
Yes.
you painted quite a different picture, didn't you?
No.
You had something to add that made you look good, didn't you?
No.
You said to Attorney Bennett, if I could have one moment, Judge, I just want to get this exactly right. Just need a moment, all right?
No problem, take your time.
Page 11, counsel. The 80-something page report, 90-page report. With respect to the CIC report, you did say the part that she was saying it hurt. I told her to just keep breathing. Do you recall that?
Sure.
You have a son, you want to be here for your kid. Does that ring a bell?
I didn't hear that.
I'm sorry, you have a son, you want to be here for your kid.
Okay.
You said that to Mr. Bennett?
If it's there, yes.
Then you added something quite memorable that you didn't say here in court. Isn't that correct?
You tell me what's in it. I don't know.
You said that she reached up, she grabbed my hand, I held her hand, consoled her, and then I asked her, why? And she stopped talking and just literally just looked right through me, death stare.
If
That's
it's there,
what you
then
said.
yes. If it's there, that's what I said.
And you didn't say that here in court today, did you?
I didn't remember. I totally forgot about that.
You forgot about something like that.
Mm-hmm.
Nothing further, Your Honor.
I'm sorry, no more, you're done?
Yes.
Okay, redirect.
So I'm going to show you what's been previously marked as exhibit number 57. Is that a better picture of that
Yes.
area that you put the gun,
Yes.
that officer portrait?
Yes.
You You also stated, just during cross-examination, that you knew Ms. Fitzsimmons had been sectioned before, correct?
That's correct.
And did you know that before the call?
I did.
Okay. And did that factor into how you were assessing the situation in the house?
Yes.
Did that factor into the team, you, Houston, and Daly, about the fact that you were never going to take your eyes off her?
That's correct.
Counsel had asked you about the first time you making a statement about what happened was July 3rd, correct?
Yes.
Did you tell anybody what happened before that?
Before
I didn't
July?
hear that.
Oh, sure, I'll say it again. Counsel had asked you whether you had, the first time you made a statement about what happened in the room was July 3rd, correct?
Yes,
Okay. Did you tell Officer Corr what happened?
I did.
Did you tell Lieutenant Daly what happened?
I did.
Did you tell Officer Houston what happened?
I did.
What did you say?
I said she tried to shoot me.
Thank you. Nothing else.
Objection, Judge, that's hearsay, and I have a motion to strike.
Okay, it's overruled. Do you have recross?
No, Your Honor.
I'm not, just to be clear, I'm not, Mr. Bradle, I'm not, I did not allow that last statement in for the truth, just for a state of mind,
Thank you.
and to rehabilitate as well. All right, no further questions for Officer Noonan from either side? I take the silence as a no. Thank you very much. You may step down, and Commonwealth, you can call your next witness. Well, before the witness departs, oh, you were almost out of here. You didn't move quick. You didn't move fast enough. All right, yeah, we can go to sidebar. Just stay around. Okay, thanks. Go ahead.
I don't have to say it.
Thank you. And Commonwealth, you can call your next witness.
Stephen Corr.
Could you raise your right hand? You solemnly swear that the testimony you're about to give in this cause now with hearing shall be the truth, the whole truth, and nothing but the truth to help you God.
Yes, I did.
Good afternoon, you can have a seat, or I guess good morning still.
Hey, good morning, Your Honor.
Okay.
Yes, please.
Sir, in a loud, clear voice, can you please introduce yourself and spell your first name and your last name?
Good morning, my name is Officer Stephen Corr. Stephen spelled Steven, last name is Corr, Corr.
And what do you do for a living, sir?
I'm a police officer with the town of North Andover,
And how long have you been doing that?
about 15 years.
Okay, what are your duties and responsibilities now?
I'm on patrol 4 to 12 shift. We respond to everything, 911 calls, domestics, motor vehicle accidents. If somebody calls the police, we answer.
Okay, I'm going to turn your attention back to June 30th of last year. You were working that day.
Correct.
Okay, at some point in the early evening, did you get a call to go somewhere? Or did you get a call that you decided to respond to?
There was a call, we had several officers involved in a document service.
Okay.
I was assisting another officer at a time with an arrest.
Okay, and the document service was a restraining order?
Correct.
Fair to say that was being served on Kelsey Fitzsimmons?
Yes,
Okay, did you know where she lived?
I do.
You did?
Yes.
I'm sorry, I was about to say I didn't hear your answer, but he repeated it, so you knew where she lived.
I do. Yes, correct.
Sorry, we're having trouble hearing the gentleman too. If you could
Well,
just
I'm
try to
sorry.
keep your
Excuse me.
voice up. Thank you, sir.
Sir, you said you were on another call, correct?
Correct.
Whereabouts was that?
It was down the road on Waverly Road by the cemetery.
At some point, did you receive information that necessitated your presence at Ms. Fitzsimmons' residence?
After I had cleared that call with another officer, I had saw on the control board of my cruiser that they were getting out at that residence, and I started floating that way prior to receiving radio transmissions.
Okay. And before you got there, did you receive another transmission?
I did.
Okay, what was that?
I believe it was Lieutenant Daly had called off, and in the background, it was just a woman screaming and him saying shots fired.
Okay. And so did you head that way?
I did.
When you got there, was anybody else outside when you got there?
There was another person in a small red car that had pulled up next to me as I had gotten out. I spoke with her briefly about somebody running down the street with a child.
Okay. Had you seen that person running down the street yourself?
I did not, no.
So what did you do after you stopped?
After I stopped, I grabbed my med bag and I radioed up to Lieutenant Daly. I said, where are you, sir? And he answered me on the radio, said, upstairs. I think he said upstairs.
Had you ever been in that residence before?
I have not, no.
Okay. So where did you go?
I went in the porch on the left side, went in through the front door. I could hear a female screaming. I think I went inside and asked her, where are they? And she said, they're upstairs. I went upstairs. And there's a weird kind of layout of the house where you come in the front door and the stairs are right behind it.
Okay. Now you said the woman screaming. Was that the woman downstairs was screaming?
Woman downstairs, a living room, family room on the left, yes.
Okay. You went upstairs.
Correct.
When you got upstairs, what did you see initially?
I got upstairs, there was a landing way with a left exit and a right exit. There was two doors. I could hear commotion on the right side, so I entered that doorway.
Okay, and who did you see when you entered that doorway?
I saw Lieutenant Daly, I saw Officer Noonan and Officer Houston.
What were they doing?
They were performing first aid, rendering aid to Ms. Fitzsimmons.
At some point, did Officer Noonan ask you to do something?
He did.
What was that?
He pointed right where his hand had been, and he said, secure that firearm. And I had looked down, there was a firearm sitting on I want to say a white-looking bookshelf.
Okay. Was that near the door?
Correct.
Picture right now. I'm going to show you what's been previously marked as exhibit number 57. Do you recognize that?
I do, yes.
And what is that?
That was where the firearm was located on top of the white-looking bookshelf. I guess it's not a bookshelf, but
So this is the room you entered, correct?
correct,
And this is the door you went in?
correct.
And is this the area where the gun was?
That's where the gun I saw was, yes.
Okay. And so you didn't know anything about the gun at the time, whether it was loaded or not, right?
No, I did not.
Okay, so what did you do?
I had gloves on at the time. I picked up the firearm. There was a small black box on the bed. I saw that was an open box where I could store the firearm because I knew paramedics and fire department was going to be coming in that room. It's not a huge room, so I wanted to get it out of the way so it wouldn't be trampled, wouldn't be disrupted or anything. I took the firearm. I looked at the box. There was nothing in it. I kind of did one of these motions to make sure there was nothing in it, put it down. I dropped the magazine out of it.
And what does that mean, dropping the magazine?
I hit this release button on the side of the firearm. It takes out all the bullets that are in the magazine.
Okay. Bullets stay in the magazine.
The bullets are in the magazine, correct? And then after that, I racked the slide, had it sideways, and I emptied a round out of the chamber into that box.
Okay, so there were a magazine with a number of bullets in it.
Correct.
The one round or bullet was racked into the chamber itself, correct?
Correct.
And then did that go in the box?
That went inside the box.
And what did you do with the firearm itself?
The firearm, I put everything in the box.
Okay.
And then brought it outside of the room.
May I approach, Your Honor?
Yes.
I'm going to show you the picture and ask if you recognize what that is.
Hold on a sec. So this image.
Not agreed to, so it's a picture that.
Okay. All right. My question was, you just answered it by your movement, was whether you wanted me to look at what was on the screen.
No.
All right. So you've handed him a photo.
You recognize what that is?
I do.
What is it?
It's the box that I placed the firearm on the ammunition in.
Okay, can you see the firearm, magazine, and the round itself?
I can.
Okay. Where is the pic? What did you do with the box after you placed the items in it?
Like I said, it was a small room. The landing that was at the top of the stairs, I backed up out of that and I put the box in the corner away where I kind of stood over it, made sure nobody messed with it as the fire department came up and down for medical aid.
Thank you. I draw right off of this picture is the next exhibit.
Any objection?
No, Your Honor.
Okay. It may be admitted.
Exhibit 80, so marked.
If I may publish it.
Please.
Is that in the position where you had placed the box itself on the landing?
Yes.
You said you stood guard over it. Until when?
As they were doing render and aid, Officer Noonan backed out of the room along with Officer Houston and I believe Lieutenant Daly. As she was being removed from the room downstairs, there started to be some issues. I asked Lieutenant Daly, who was standing next to me, I said, do you want me to go down and make sure the fire department's all set, putting her in the ambulance, make sure nobody interferes with that? And he said, yep, I'll take watch over the firearm. And he basically stood over it and made sure nobody, after I had left.
Okay. When you initially went into the room and you saw Ms. Fitzsimmons on the ground, I'm assuming?
She was blocked my view. I could see feet.
Okay.
I assumed that was her. Once everybody kind of moved out of the way and I walked in, I said, what do you guys need for help? They already had a med bag up there, but she was on the back side of the bed.
Okay. Where was Officer Noonan after the fire department left?
Standing next to me in the hallway, the landing area, I want to call it.
Did you do anything with regards to him? Did you make any observations with him?
I asked him if he was good. It's basically me making sure he's okay. Adrenaline's rushing. As I came up the top of the stairs, there was a little glass door on the left, and it looked like there was like a pinhole through it. I thought he might have been shot at, so I asked him, "Hey, did she get a round off on you?" And he basically, I don't know.
Overruled only because it's been admitted and it's of marginal relevance, just to explain the scene. Sure. Cross? Mr. Brito, cross?
Thank you, Mark. Thank you so much.
Yes, take your time.
Officer Core, good afternoon, sir.
Good afternoon.
Now, I'm sure that you memorialized all these important facts you testified to in a police report somewhere.
No, we didn't generate a police report at that time, no.
Well, I'm not asking if we did, I'm asking if you did.
I did not know, sir.
Excuse me one moment. Do you mind going to the?
Oh, sorry.
microphone only because, to make sure that the audio gets picked up.
Everything you testified to was not memorialized by you in the police report, correct?
No, I did not write a police report, no.
Now, also, you weren't interviewed until 30 days after this incident, correct?
Interviewed by who?
By the state police.
I don't remember the exact time frame.
Isn't it true that you were interviewed on July 30th?
I don't know the exact date. If that's what you say it is, then I assume you're giving me correct information.
I appreciate that. You were also working with Officer Noonan, correct? At the time-
I work
in
with
that
him
time
as a
interval?
coworker.
Did you work with him in that time interval?
From when the incident
to the
happened,
30th.
July 30th,
July.
he's on a different shift, but yeah, I do work with him.
And did you speak with him about the case?
I don't recall if we did. I'm sure we had talked at some point about if he was okay.
Did you speak to him about what happened at the scene? Just yes or no?
At the scene we did, absolutely. We were on the same scene.
And did you speak with him in the days following?
I couldn't tell you. I'm sure we at some point talked.
And what about prior to your state police interview?
I'm sure we talked at some point.
So you spoke with him at the scene, spoke with him probably shortly after, and spoke with him prior to the interview as the interview approached. Is that fair to say?
Yes.
Thank you very much. Nothing further.
Anything you got? No. Okay. All right. Thank you, officer. You may step down.
You're welcome. Thank you.
Commonwealth, you can call your next witness.
Thank you, Your Honor. Michael Buenos Aires.
You solemnly swear that the testimony you're about to give in this cause now and hearing shall be the truth, the whole truth, and nothing but the truth to help you God.
I do.
Thank you.
You may have a seat. Just pull yourself up to that mic. Thank you.
May I?
Yes, please.
Good afternoon, sir.
Afternoon.
In a nice loud voice, if you could please state your name and spell your first and last name for the record.
Sure. My name is Detective Lieutenant Michael Bonasoro. Last is spelled Bonasoro.
How are you employed?
I work for the Mass State Police.
And what is your current assignment?
I work for the Firearms Identification Section.
How long have you worked for the Massachusetts State Police generally?
Almost 20 years.
If you could give us a brief recitation of your assignments within the state police?
All assignments are what I'm doing now.
Start from when you graduated from the academy, briefly.
All right. So graduated academy in 2006. From there, was on the road for a few years, transferred into the Firearms Identification Section, stayed there for approximately 12 years, transferred out of there, went to the Narcotics Inspection Unit for a year and a half, went to the duty office for a few months, back to the Narcotics Inspection Unit, and then to Firearms Identification Section again to work as the executive officer and now the unit commander.
And so how long has your current assignment with the Firearms Identification Unit been?
Since I've been back a little over 3 years.
What does the Firearms Identification Unit do?
So we have many responsibilities. So we respond to crime scenes, preserve the evidence, document the scene. We do microscopic comparisons of fired bullets as well as discharged casings. We attend autopsies, we destroy weapons, and we do functionality of weapon certifications.
How many troopers are assigned to your unit statewide?
There's a total of 18 of us assigned statewide.
And what are your responsibilities as the detective lieutenant in charge?
So I look at training, make sure we're up to accreditation standards for lab protocols, making sure all of our protocols are in line with the current definitions of Mass General laws. I look at different aspects of how we respond to scenes, how we collect evidence, how we interpret evidence, looking at the definitions of firearms, ammunition, semi-automatic pistols, rifles, shotguns, assault weapons, different stuff like that. It's more of a managerial role. We're looking at making sure everybody has the training that is required amongst them and authorizing them to do the casework when they have achieved all their training.
And fair to say that you still, from time to time, respond to scenes yourself?
Yes, so as of right now, we're down a few supervisors, so I took on the role of going to these more high-profile scenes to observe my other ballisticians, collect evidence, as well as do some of the hands-on work myself.
Can you briefly summarize some of the specialized training you've received over the years with respect to firearms?
Sure. So when you go into the firearms identification, it's a 2-year apprenticeship program. You work with other senior ballisticians. You're looking at casework, seeing how to do the casework, making sure it aligns with the protocols that we have documented. You're doing test fires of weapons, numerous weapons, analyzing ammunition, magazines. You go into armorers courses, you go into different conferences to look at the field of tool marks and seeing how these tools are making these markings and how they're transferring over to these discharge casings and projectiles. So it's an ongoing process of different trainings here. It's training from other examiners, see what they've discovered in the field and making sure you're up to date with all the standards.
And the armorers courses that you've gone to, have you gone to numerous with respect to the common gun manufacturers in the United States?
Yes, I've gone to several rifle, shotgun, firearm armorers courses.
Can you estimate how many weapons you've examined over the course of your career?
Hundreds.
And how many weapons have you test fired?
Over hundreds of them as well.
And do you also have the opportunity to examine ammunition as part of your work in the firearms identification unit?
Yes, looking at the components of ammunition, yes.
And one of the components of ammunition is projectiles?
Correct.
And you've examined estimate how many projectiles over the course of your career?
Thousands.
And how many scenes have you responded to?
Hundreds of scenes.
And have those been both fatal and non-fatal shooting scenes?
Yes.
Have you conducted and participated in the microscopic examination of ballistic evidence?
Yes, several.
Approximately how many times?
I would say over 100 cases.
And have you had the opportunity to testify in the courts of the Commonwealth?
Yes, several courts.
And if you could name a few of those courts.
Middlesex Superior District, Suffolk Superior District, Worcester Superior District.
And today you're in Essex.
Yes.
Before I ask you specific questions about the case, I just want to ask you some general questions about how firearms work and how ammunition works. Can you explain the components of a live round?
So you have several components. So you have the casing that encompasses everything. You have the powder that's inside of it, and then you have the projectile, and you also have the primer. So you need all these components to make ammunition. So all these components combined will make one combustible material. You'll have what's called a firing pin. It'll strike the primer. Primer will ignite the powder inside of the casing, which holds everything together. Once the gases build up from the burning of the powder, the projectile will leave that casing.
So the projectile is what's commonly known as a bullet?
Yes.
And the casing is what is often recovered at crime scenes?
It's also referred to as a discharge cartridge casing, so it's been extracted from that firearm.
Is there a way for you to determine whether a round has been discharged from a working firearm?
There is. So you're looking at the tool marks of what's left over on that discharge casing or that projectile. So originally you look at the class characteristics. Does it have the same design features as that firearm? Is in regards to a projectile, is the twist going to the left or the right based on that design feature of that firearm? If it twists to the left, it would sometimes be 6, 5, 4 right twists. So you look at these characteristics, make sure they're in line, and then move forward into what's called individual markings. As firearms are produced, they're produced by tools. As tools are making these firearms, the tools are wearing away. You also have little pieces of metal that get in front of the tools, which will create unique marks. There isn't one firearm that is the same due to the fact that you'll have material that's in front of these cutting edges.
And is it fair to say that when a cartridge is new or from the box, it does not have these particular tool marks you're looking for?
It shouldn't have any of the tool marks. It may have some type of markings, what's called bunter marks on a discharge casing. This is from stamping that live cartridge to indicate what caliber and manufacturer of that live cartridge.
Sorry, did you say what marks?
A bunter mark? A bunter mark?
Can you spell that for the court?
It's bunter.
And that's the stamp that reflects the caliber of ammunition?
The caliber as well as the manufacturer.
Thank you.
When a casing comes apart from a projectile, does it come out with velocity?
It does.
And are you able to determine anything about where a particular gun was fired based on where a casing or casings are recovered?
You can't really determine the exact location. It should land in the general vicinity of the shooter, but you also have variables if that casing was kicked or manipulated in some way, or if it deflected off another object.
And I think we just talked about this, but what does caliber refer to?
Caliber is the diameter or length of that casing.
I'd like to talk about a semi-automatic firearm. Are you familiar with those?
Yes.
And how does a semi-automatic firearm work?
So it requires a trigger pull per firing of that weapon. So you pull the trigger, it will cause either a hammer or a firing pin to move forward. It will strike the primer. After it strikes the primer, it will cause an explosion. Explosion is going to cause that slide to go backwards. The extractor is going to extract that casing, which is attached to that slide. It's going to hit what's called an ejector. The ejector is going to extract that discharge casing out of the ejection port, and it's going to continue the cycle. This slide is going to move forward now because it's under spring tension. It's going to pick up that other live cartridge that's in the magazine well and load the next live cartridge.
But does the user have to do something first before they are able to pull the trigger and have a projectile fire?
So they would have to load either manually or with a magazine. So a live cartridge has to be inserted into the chamber.
And does the slide, or does the slide have to be pulled back?
The slide has to be racked to the rear, yes.
Okay. And so the slide has to be racked to the rear just one time before the shots are fired?
Yeah, so you have to essentially cock the firearm. So you have to put some external force on that firing pin or that striker to hold it in place. When you pull the trigger, you're going to have that transfer bar or that trigger bar, whatever you want to call it, will actually drop. Will engage that trigger bar or that striker to move forward and move past the aperture, which is the circular portion, and right in front of the primer that sits in front of the chamber. So all these things have to happen, but initially you have to have a cocked firearm for it to happen. So you have to load that live cartridge and put some external force on that slide to cock it.
And is cartridge synonymous with magazine?
Cartridge versus magazine. So a cartridge would seat in a magazine.
So the cartridge holds the projectiles or casings in the magazine?
Yes.
Okay. And what part of the gun is the magazine?
So it's an external piece that's inserted into a magazine well.
So a user would take the magazine, enter a cartridge which contains the bullets, and then seat it in the handle of a semi-automatic weapon?
So the person would load the ammunition inside of the magazine. The magazine will have a spring tension as well as a follower on top. That spring tension pushes that live cartridge to the top of that magazine at all times. That live cartridge is stripped by the slide or manipulated by putting that live cartridge in the chamber manually, but ultimately you do have to cock that weapon to fire it.
I'd like to direct your attention to June 30th of last year. On that date, in the evening hours, did you get called to go somewhere?
I did.
Where did you get called to go?
To a residence in North Andover.
What information did you have when you arrived?
Information I had was there was a police-involved shooting, which required a supervisor to attend the scene.
And that's why you went?
Yes.
What time did you arrive?
I don't recall exactly what time. It was in the evening hours.
Did anyone else from your unit respond?
Yes, I had a trooper, Chris Pierce, as well as trooper Andrew Valeri.
And the three of you responded from the firearms identification unit?
Yes.
And what was your purpose on scene?
We wanted to document the scene. We wanted to inventory all personnel that were involved in the shooting, whether they fired or not, to inventory their weapons, to account for all live cartridges.
And again, is that standard procedure for an officer involved shooting?
Yes.
When you responded, who was on scene?
There was several detectives from the Essex County Detective Unit, as well as Andover police personnel.
North Andover police personnel?
North Andover, yes, Mike, sorry.
Were you directed to a particular part of the house?
I was. There was a particular part in the top of the stairs where there was a firearm located in a safe, as well as a bedroom where we recovered a 2 discharge casing as well as a projectile.
And did you or someone from your unit or someone from the state police take photographs that evening?
Yes, we had crime scene services photograph the scene.
And what is crime scene services?
So they're a unit in Massachusetts State Police. So they document, they photograph the scene, they videotape the scene to preserve the scene, as well as do prints on firearms casings and so on, as well as footwear impression markings.
May I approach?
Yes.
Sir, I'm showing you 9 photographs. I just ask that you take a look at those and let me know when you're done.
While you're doing that, Counsel, Mr. Brady, will the defense be objecting to any of these?
I don't know what counsel has there.
Okay, thanks. Perhaps,
I thought there was an objection.
okay, perhaps when, hold on a second. Perhaps when you're done, when the witness is done, if you can show them to Mr. Bradle, and if, to the extent that you were able to mark a few and you can object to a few or all of them. Take your time, Mr. Bradle.
I understand there's no objection.
No objection.
Okay, let's have Mr. Wayne mark those individually. You said there were 9?
Exhibit 81 somewhere. Exhibit 82 somewhere. Exhibit 83 somewhere. Exhibit 84 somewhere. Exhibit 85 somewhere. 86 so marked. 87, so marked. 88, so marked. 89, so marked.
Thank you.
May I publish it, Your Honor?
Yes, please.
Sir, I'm showing you first what's been marked as 81. Do you recognize that picture?
The picture dictates plaque number 3. I believe there was a discharge casing around that vicinity of plaque number 3.
Sir, what number was that again?
81.
81, thank you.
Is exhibit 82 a different angle of that same, you were trying to photograph that same discharge cartridge casing?
It is.
Showing you exhibit 83. What does picture 83 show?
Discharge cartridge casing with the closer-up appearance.
Has it been moved?
I believe it has been moved.
And why was it moved?
Where it was located was kind of in a confined space in the corner of the room.
Showing you exhibit 84. Do you recognize exhibit 84?
Yes, it's where a spent projectile was recovered right above the air conditioning unit inside the curtains.
Exhibit 86.
I'm sorry, can you just give me one moment? Just check that.
Do you need the picture?
Do you mind putting that back on? Thank you.
What does picture 80, exhibit 86 show?
It's a close-up picture of placard number 4 of that spent projectile that was recovered in the curtains.
And showing you exhibit 87. What does exhibit 87 show?
The projectile from placard number 4 that was moved for a close-up photograph.
So it's taken from the air conditioning unit and moved for this photograph?
Taken from the curtain and moved on, I believe, the bed, taken a photo of it.
Showing you exhibit 89. What does exhibit 89 show?
It's where a projectile possibly struck. We looked at the air conditioner inside and to the rear of it. They had a hole consistent with a strike on the outside of that air conditioner. Can't determine exactly, but it appeared to be a projectile strike, and there was another hole on the exterior or the back end of that air conditioner as well.
And is that what exhibit 88 shows?
Yes.
And did you ever find a projectile associated with this air conditioner, the one that struck the air conditioner?
I did not.
That last photo down there, is that 85?
88.
I'm sorry, 88? Thank you.
Detective Lieutenant next showing you exhibit 76. Do you recognize what's depicted in exhibit 76?
It appears to be another discharge cartridge casing by placard number 1.
And is exhibit 77 a close-up of that discharge cartridge casing?
It is.
And what did you do with the discharge cartridge casings and the spent projectile that you recovered from the scene that night?
So all pieces of evidence were documented, where they were located by placard number, the time of location, who recovered that evidence, and any particular features of that discharge casings, the head stamps, or a bunch of marks.
So you collected the evidence and documented it, fair to say?
Yes.
And is it, in summary, fair to say that you recovered 2 discharge cartridge casing and 1 spent projectile?
Correct.
Sorry, I was distracted. Can you ask that question again?
Sure. In summary, is it fair to say that you recovered 2 discharged cartridge casings and 1 spent projectile that night?
That's correct.
Thank you.
Did you continue your search of that bedroom?
I did.
And what else did you recover from that bedroom?
I don't believe there was anything else from the bedroom other than the 2 discharge casings and the projectile.
May I approach, Your Honor?
Yes. Oh. Let's, we'll take a 5-minute recess.
All right. Let's do a 5-minute recess.
session, please be seated.
We're back on record on the Kelsey Fitzsimmons matter. All counsel and the defendant are present.
Okay, you may continue, counsel.
Thank you. Detective Lieutenant, is it true that you took possession of a number of firearms the night of June 30th, 2025?
I did.
And whose firearms did you collect?
There was 2 North Andover police officers' firearms and another firearm that was recovered at the top of the stairs at the residence.
And the 2 North Andover police officers, was that Tim Houston and Patrick Noonan?
Yes,
And did you also inspect Lieutenant Daly's firearm on scene?
I did.
And what did you determine with respect to Lieutenant Daly's firearm?
He had,
Well, I'm sorry. This almost only happens in Lawrence. But the window's open over here, which is what we need for, because of our HVAC, but I'm having trouble hearing. Do you mind closing that? Sorry, and you're gonna have to repeat those last question and answer. I didn't. Thank you. Can you repeat that?
I think so. Sir, what was your finding with respect to Lieutenant Daly's firearm?
he had 1 magazine, so he was fully loaded. There wasn't any unaccounted for rounds of ammunition.
Okay.
Wait, I'm confused because I thought you took Officer Houston and Officer Noonan is what I wrote down, but is that?
Fair to say you took Officer Houston's firearm and Officer Noonan's firearm?
Correct.
And did you take Lieutenant Daly's firearm?
I did not.
Did you just examine the number of bullets in his magazine?
Yes, I,
Well, she's leading because the judge was distracted by the outside noise, so, and I'll allow you to do so as well, Mr. Grado. So overruled, all right, so now I understand. Thank you.
And sir, I'm next going to ask you if you recognize what's shown in Exhibit 10.
yes, that is the firearm at the top of the stairs, as well as a magazine with numerous live cartridges in it, as well as 1 loose live cartridge.
Is this the loose live cartridge here?
It is.
I'd like to ask you about your major findings in this case. Based on your training and experience, did you conduct microscopic analysis with respect to the projectile and cartridge casings that were recovered from the bedroom of Phillipsbrook Road?
I did. So I test fired all 3 weapons and conducted a microscopic examination of the class characteristics, as well as the individual markings that were left behind from the firing process. I was able to conclude that the weapon that was fired by Officer Noonan created the discharge casings that were recovered in the bedroom, as well as the spent projectile that was recovered above the air conditioner.
And were you able to exclude any weapons?
I was able to exclude the other firearms.
I'd like to change gears a little and talk about the weapon that was recovered from the black safe at the top of the stairs. Did you do anything with respect to that gun?
I test fired that weapon with 2 live cartridges from submitted ammunition.
And what was your conclusion?
That weapon did not fire the discharge casings as well as the projectile that was recovered.
So the gun from the black safe was also excluded from the discharge casings and the projectile that were recovered from the bedroom?
Correct.
But did the gun operate?
It did operate, yes.
Was there any problems with its operation?
There was no malfunctions.
Did you bring with you today a box?
I did.
And what is contained within that box?
I believe it was the that Glock firearm that was in question that was recovered at the top of the stairs.
Is that box packaged in the standard way that the ballistic unit packages firearms?
It is.
if you could open the box and explain what is in the content, what's contained within.
May I assume that someone's made sure that this is safe to begin with?
I'll do it again, Your Honor.
Okay.
All right, we have a trigger lock that was provided later. We have the firearm in question. It's safe and empty. There's nothing in the chamber. The slide is locked back to the rear. There's nothing in the magazine well. The weapon is safe and empty. Also, contents of this is you have the 2 magazines that were recovered from the vest that were downstairs on the first floor of the residence. You have the magazine that was recovered in the safe. It was originally loaded with 16 live cartridges. And you have 2 test fires that are conducted using that live ammunition from that magazine, as well as the single loose live cartridge that was recovered in the safe.
Are you going to ask more questions about that? Because I couldn't keep up. Or should I have them repeated?
No, I will ask.
Okay, thank you.
But in the meantime, may the box and the contents be marked for as an exhibit?
Yeah, let's. We're gonna have to do them individually. I don't want the ammunition to be with the firearm. So let's do that, Mr. Ruane. And also, any objection if he puts, Mr. Bradle, if he puts the trigger lock on there?
No,
I don't know, are you able to even?
object to the meeting either for this. I don't object to any meeting for this kind of stuff.
I would ask that you just wait to
Sure,
put the trigger lock on, certainly before it's submitted.
sure. Thank you.
How about we do the gun in the box and then the rest we can tag individually?
Sure.
Exhibit 90 would be the firearm, Your Honor, in a box.
Yeah.
91 is a magazine, Your Honor. And 92 is also a magazine, Your Honor.
Is it with the ammunition?
Yes.
Okay.
93 is in magazine.
93 is a magazine with ammunition.
Live round.
94 ammunition, 1 round. 95 test fired ammunition. 96 test fired ammunition.
The magazine that you recovered from the gun in the black safe, what was the total capacity of that magazine?
17 live cartridges.
And is that how many live cartridges that weapon can hold?
That's how many cartridges the magazine can hold. So what's called a top-off method. So you'd load the magazine with the 7 live cartridges. You would chamber around. You take the magazine out of the magazine well, and then insert another live cartridge. So essentially, the magazine will be fully loaded with 7, and then there will be 1 live cartridge in the chamber.
So you said 7, not 17.
My apologies.
No, I'm asking, that's a question. You mean 7, right? Not 17?
7. The magazine is 17 live cartridges capacity.
17
17.
is the capacity. Okay.
17 is the capacity for the magazine that was recovered from the black box.
Correct.
And so when you add an extra round, what's the capacity for the weapon itself?
So we'd call it 17 plus 1, so essentially 18 live cartridges.
So getting back to that, in that black box, in this, I'm showing you Exhibit 80. Exhibit 80 is the gun, the magazine, and the single live projectile that is contained within the box in front of you. Is that correct?
Yes.
And when you examine this firearm, how many bullets were in the magazine?
There were 16 live cartridges in the magazine.
And how many live projectiles were in the safe?
There was 1 loose round live cartridge in the safe.
And that is reflected in the 1 loose round cartridge. That's in Exhibit 94, is that correct?
Correct.
Are you familiar with the term dry fire?
I am.
What's that mean?
So you are cycling the weapon without a live cartridge in the chamber. So all the same steps are going to happen. You're going to cock that weapon. It's going to have that trigger bar or that striker be sent to the rear. It's going to be held in tension by that trigger bar. When you depress the trigger, it's going to create that trigger bar to drop. The firing pin is going to move forward through the aperture and potentially strike any live cartridge that's in the chamber.
And what happens if there's not a live cartridge in the chamber?
So you'll hear an audible click.
With the court's permission, may Detective Lieutenant demonstrate?
Any objection?
No.
Demonstrate
A dry fire with no projectile in the weapon at all, no projectile particularly in the chamber.
Yes.
So if you could stand up and demonstrate.
Okay. Again, there's nothing in the magazine well, nothing in the chamber currently. So the weapon currently is cocked. We've moved the slide forward, still in the cocked position. You still have that trigger bar, it's moved backwards. And then when you pull the trigger, you'll hear an audible click because it's releasing that striker. That striker is going to move forward and hit where the aperture where the firing pin would protrude. So you'll hear the click. And then in order to reset it, so right now you have a dead trigger, it's not going to do anything. Again, pull the trigger, audible click. And that's what you'll hear. If you have nothing, if it's halfway, you'll have a click as well. So if it's not all the way chambered, it'll click as well. So what we call it is out of battery. So the weapon is locked to the rear. You'll have the slide forward. Now the weapon is battery. So you have an enclosed live cartridge. There's nowhere for that live cartridge to go when it's fired, but out the barrel.
And I'm sorry, the term that you used, batteried?
It's out of, so once the live cartridge is loaded, that weapon is now in battery. So you have the breech that is right behind that live cartridge. So when you fire that weapon, an explosion is going to happen. So you're going to have the firing pin is going to hit that primer. Primer is going to ignite the powder. Powder is going to build up gases. Projectors are going to go down simultaneously. You're going to have an explosion, which is going to cause that slide to go backwards. The extractor is in contact with that live cartridge. It's going to rip that discharge casing out. It's going to hit the ejector, which is pretty much a metal rod, and it's going to eject out this ejection port, which is right here. There's an ejector right in there. An extractor is like a little claw that's attached to that rim of that live cartridge or that discharge cartridge after firing and pulling it right out. All in one function, and then that slide is going to go forward and load the next live cartridge.
Thank you.
So based on your training and experience, would you hear that click if there was a loaded magazine in the weapon, but no bullet in the chamber?
Yes.
And based on your training and experience, what would happen if the gun was cocked and there was bullets in the magazine and you pull the trigger?
If there wasn't any live cartridges in the chamber, nothing would go off. You'd have a click, but nothing would go off.
And then how would you get a bullet to go into the chamber?
You'd have to physically, manually load that bullet or push that slide forward to load that live cartridge from the magazine.
May I have a moment, Your Honor? Thank you. No further questions.
Hello, sir.
Afternoon.
Lieutenant Detective Bonasaro, do I have that right?
Detective Lieutenant Bonasoro.
Bonasaro, nice to meet you. We had never spoken before, correct?
Correct.
So what's a head stamp on a cartridge?
It's the indicator that tells you the caliber and the manufacturer.
Was that something that you took note of for all the cartridges in this case?
Yes.
And and you can look at any of your reports if you like, or anything you need to look at, you can just let me know. Or you can just go right ahead and do it. Do you have your reports with you?
I don't have them with me, no.
Okay. And let me know and I can show you. In this case, relative to the spent projectiles that you recovered and the loose round you recovered, did you check the head stamps of those?
All head stamps were recorded on all evidence, yes.
And they're on your ballistics worksheets, right?
Yes.
And if you need to look, just let me know. All the head stamps for all these cartridges were the same, right?
I believe so.
It was Hornady 9mm.
Yes.
Okay. And so just out of an abundance of caution, I don't want you to believe so. I want you to look and just tell me. Is that all right?
Yes, that's
I'm pretty sure I'm giving you everything. And if I don't, just let me know. And I have 3 ballistics worksheets here. May I approach, Ron? Yeah. Let me show you those. Take a look. Take all the time.
And then, just so I'm clear, Mr. Bradle, the question is whether all the ammunition recovered had the same head stamp?
Yes.
Okay,
Correct,
thank
Your
you.
Honor. So with respect to, actually, I should qualify that a little more, Your Honor.
Sure.
The question was, the 2 spent projectiles and the loose round, do they all have the same head stamp?
the 2 discharge casing as well as the loose live cartridges all have the same Hornady head stamp.
And I apologize, and you just corrected me. I said spent projectiles. That's wrong, isn't it?
Correct.
So I should rephrase that, Your Honor. The 1 live round, live cartridge, and the 2 shell casings all had the same head stamp. Correct. Thank you. And I said that right that time, right?
Yes.
All right. I'm just going to retrieve those from you.
Sure.
As a state police detective, you go to various towns and you investigate ballistics evidence, ballistics issues at various calls, right?
Yes.
And oftentimes you get there kind of well after the fact of the incident, right?
Correct.
And in this case, I know you don't exactly remember the times, but let's break it down a little bit. How long did it take you to get to the scene, if you recall?
Probably over an hour to get there. I was traveling from Maynard.
Okay, so Maynard to North Andover, and it's was it dark out when you got there, if you can recall?
I don't recall exactly what time I got there.
It's fair to say that the scene was secured and there was no there were no civilians around. It was a crime scene that was in the possession of police.
Safe to say there was a secure scene, yes.
And you saw colleagues from the state police that are assigned to the state Essex Detective Unit, right?
Correct.
And you also saw some North Andover police officers as well, correct?
Yes.
And it's fair to say that the North Andover police officers were having free reign over that scene when you were there?
I wouldn't call it free reign.
Well, nobody was keeping them out of there, right?
I believe they had a log of who was going in and out, but it's not my responsibility to keep track of who's in the scene.
Certainly not. And you oftentimes don't have personal knowledge of what goes with what cartridges from what gun, things like that.
Correct.
And you often have to rely on what people at the scene tell you.
Yes.
And then you can also, however, apply your science and figure out to a reasonable degree of ballistic certainty what the relationships of certain projectiles, cartridges, and firearms are, right?
Yes.
And in this case, you don't have any personal knowledge of the chain of custody of these various firearms, do you?
What was recorded in my notes of who I recovered these firearms from is all I can.
Well, we can start there, and we'll go through it. So you wrote a report, and again, if you want to look at this, just let me know. You wrote a report that involved 3 Glock firearms, right?
Yes.
Okay. And actually, it might be quicker, Judge, if I give him one of these, so I don't have to keep going back and forth with that.
Let me ask, Mr. Brady, do you think that now's a good time to break for lunch? Do you think?
Sure,
And then,
that's fine, Judge, and I'll have the paperwork for him, and we can just go
Okay.
without having to go back.
Yeah, maybe let's do that. So
Thank you.
we'll stand at recess and let's start back up at 5 of 2.
Should we have him put the gun lock on?
I'm sorry, hold on 1 second.
Should you put the gun lock on?
Yeah, do.
Okay. 2025, 77 CR 311. All counsel and defendant are present.
Okay, and I think we left off during cross.
Yes. May I resume your?
Yes, please.
Thank you. Lieutenant Detective Bonasar, you have a copy of your report, right?
I do.
Okay. And there's other documents too. You have worksheets and other items, correct?
Correct.
So if you need anything, just let me know and we can share anything you need, okay?
Okay.
What is meant by chain of custody of an item?
Who has actual custody of that particular piece of evidence? It's moved from one location to another or one person to another.
So as a piece of evidence kind of goes through the investigative process, sometimes it can be important to make sure you know who had it, where did it go, as it goes through, right?
Correct.
And in this case, it's fair to say that you don't have personal knowledge of a lot of the chain of custody here.
I have personal knowledge of who I received the firearms from.
Right, okay. And we'll go through that. And I'm not questioning, in terms of chain of custody, you and the state police going forward from when you left the crime scene. I want to ask you some questions about chain of custody at the scene, okay? Who did you get, and again, you can refer to your report here. Item 1-1 is a Glock 47, and we'll just use the last three numbers of the serial number, 269. Who did you get that from?
What was
the item number again?
1-1, Your Honor.
Thank you.
Yep. And the last three digits of the serial number are 269.
Thank you.
And so that gun, and again, you can look on your papers, anything you want. Do you know who you got that from?
If I could see my notes, the
Sure.
worksheet notes
Yep.
from the crime scene.
Sure.
Yeah.
Let me see if I got this right. These would be the notes, right? And this is just another copy of that report.
Yes.
So 1-1, take all the time you need. Who did you get that from?
It was received from Detective Lieutenant Michael Davis.
Okay, and who's he?
He works for North Andover.
All right. And do you know whose gun that is identified to from the incident?
Based on the serial number, I was told it was Officer Noonan's weapon.
Okay. And are there some notes in that packet you have there from you that indicate that Chief Gray had that gun for a while?
Yes.
And what are the indications that, how did Chief Gray come to get Noonan's gun?
I was told that he had custody of the weapon and he unloaded the weapon at some point and he put the live cartridge that was in the chamber back into the magazine.
Okay, so Chief Gray is manipulating Noonan's firearm. And I mean the word manipulating in the physical sense.
Yes, this is what I was told.
And then it goes to who? Lieutenant Reardon, was it?
Detective Lieutenant Michael Davis.
Davis, sorry. And then Davis gives it to you?
Yes.
And that's just what you have documented, right? You don't have any knowledge of any other people having it, right?
Correct.
Presumably Noonan had it since it was his firearm at some point.
Presumably.
And, all right, so that's 1-1. And item 1-2 is a box magazine from item 1-1, correct?
Yes.
And it's got 16 cartridges in it, and the capacity is 17, right?
Yes.
And so you say right in your report Noonan's gun, right?
Yes.
Then 1-3 is a little different, isn't it?
Yes.
You write there, one removable box magazine from, but then you didn't fill in who it's from, right?
Yes, that was an error on the administrative portion of the report.
Okay. And just so we're clear, this is your report.
Correct. Yes.
Okay. So it was never noted where the 1-3 is from, correct? In terms of the gun.
It was noted that it was received from Officer Michael Logan, 1-3.
So he's the chain of custody guy, but unlike 1-1 and 1-2, where you match them up, that the magazine is from 1-1, here, it doesn't say where that magazine is from, right?
Well, these were recovered at a later time.
Mhm.
I was initially given the firearm with the magazine, and then later on, these additional magazines that were recovered from, I believe, the either the duty belt or vest carrier, whatever the officer had.
And you know, I'm just asking you about what it says. I'm not trying to suggest there's fault. And I just want to go through it with you in terms of what's identified and what's known to be from somewhere and what's not. Okay? So I'm not trying to find fault. I just want to factually have us go through the report. So we don't know where 1-3, the box magazine, is from, what device it's from, right?
I was told it was from either the vest carrier or the duty belt of Officer Noonan.
But that's not in the report, is it?
It is not.
And then same with 1-4, one removable box style magazine from, and then from is not identified, right?
Correct.
Okay. And that's the same thing. You got a magazine, and that's from Officer Logan as well. The chain of custody references from Logan, right?
Yes.
And again, it's not identified in the document where it comes from. Yes?
Correct. Correct.
Then 1-5 is another Glock 47. So it's just to cut to the chase. All three guns you have are Glock 47s, right?
Yes.
And that's a semi-automatic firearm that was, to your understanding, issued to the North Andover Police.
Yes.
And each one obviously has its own serial number,
Correct.
but otherwise they look the same.
Yes.